excited about. We've been prepping this for a while. I have with me here our I'll tell you what, I'm not going to go for my notes here, but we have CJ Grisham, the founder of Open Carry Texas, and Benton Ross Watson, our very own attorney extraordinaire, here weekly on the show's License to Carry segment. Together, these gentlemen are going to go over the Grisham gun case that blew the doors wide open for Texas to be able to carry handguns in the open. Okay, let's, open carry. Let's start off by saying hello to each one of these guys, and then I'll read the brief summary as to what's going on with CJ's case, and then these two guys are going to get at it, and I'm going to bump in from time to time, but I'm going to be sitting in the wings just listening, because this is going to be interesting here. So first of all, CJ, welcome to the show again. You've been on a couple of times. Tell everybody who you are, whoever's been under a rock and they don't know who you are. Let's tell them who you are.
Well, I'm not anybody important. I'm just retired from the Army as a first sergeant. I'm a student. I go to school trying to finish up a degree so I can go to law school. But then I am also the founder of Open Carry Texas. I'm a huge gun rights advocate. People have started to call me Mr. Texas 2A, and I don't know if that's something I feel good about.
Clarify that. What's that?
It's the Second Amendment, Texas 2A.
Oh, 2A, okay.
Mr. Texas 2A, and apparently they think that's the only thing I care about. But I'm a very strong believer in all liberty.
I want to make a point here. That may not be the only thing you care about, although it's very dear to your heart.
It's
but
very dear to my heart.
Sometimes the Lord puts you in a position that is necessary for you to do, and for some reason you're that man, CJ. So.
And you know what? If that's what He's going to use me for, I'll make use of that.
Okay, sounds good. Okay, what else? First of all, how can people make contact with you?
It's easy. OpenCarryTexas.org is our website. My email is very simple, cj@opencarrytexas.org. You can call the number on our website. Sometimes I'm able to answer it, but I've got a few other people. It rings to 5 phones at a time. So very easy to get a hold of. Just OpenCarryTexas.org. Send me an email, cj@OpenCarryTexas.org.
Sounds good. Now, to your left, we have Benton Ross Watson here, our attorney extraordinaire. And I don't say that lightly, man. I love your passion, Ross. I love it. So say hi to everybody. Tell everybody how they can get a hold of you.
Cameron, 105 East Main Street. Again, you guys know my number, 254-455-0569.
You got to remember, people come in and out of this show every 3 minutes. So tell everybody who you are, how they get a hold of you.
254-455-0569. Again, the main office is in Cameron, Texas, 105 East Main Street. You can find me with the big milk cow on the side of the building. That's me. So.
Okay. Now, listen, everybody.
This is the kind of attorney I want to be like.
Yeah, right. This guy's got a passion.
I'm a small fish in a small pond, like I was telling you. I just fight these liberty battles every day.
Yeah, but you're that type of fish that jumps into the bigger pond and grows, so that's really good. Okay, now listen, everybody. If you want to go to aaronsgunshop.com, go to the Facebook page, because we're streaming live here. You get to see these ugly mugs here in person. You're just checking it out. I got CJ on. Let's see if you're going to look at it. He'd be on the left. You got Ross on the right, and I'm going to stay off screen because I'm ugly as it is. But now I'm going to read to you a paragraph here. We've been doing notes here. We want to get all our notes right. So I'm going to read to you a paragraph to set it off, and then CJ and Ross, I want you guys just to get at it, man. Just talk, okay? Here we go. The charge and trial. Grisham is charged with resisting arrest, but the district attorney reduced charge to interference with public duties. Grisham goes to trial, jury trial. Apparently jurors were deadlocked, leaning towards not guilty, but then, hold on, I got a fly in my face. Okay. But when they sent a question to the judge about the jury charge, he responded in such a way that swayed their vote 5-1 in favor of guilt. Nevertheless, one juror held out, and held out so long the judge declared a hung jury, or a mistrial. The state retired the case. This time the state convicted, and Grisham appealed the Third Court of Appeals in Austin, claiming that there was no reasonable suspicion for the police stop, thus no probable cause for the arrest, and that the judge erred in failing to submit a jury instructions on the law of self-defense. The Third Court of Appeals upheld the jury's verdict, meaning Grisham lost. So with that, you're going to be talking about the potential issues, and there's a whole bunch to go over. So I'm just going to step out of it. Guys, go to it. Let people hear what's going on the back side of things, so they can get a good, full understanding of where we're at on this case.
And really quick, I'll add something to that. In the second case, before there was the conviction, the jury was actually 4-2 in favor of acquittal at that point. And it wasn't until the judge basically refused to answer some questions, because they had asked him several questions about the meaning of certain words, and he said, I can't give that to you.
Now, I want to ask a question to Ross. Why would a judge do that? I don't understand that. Why would they refuse based on the terminology here?
Well, because, one, the judge doesn't want to comment on the weight of the evidence. If the judge's notes or a comment that he sent back to the jury were seen as being one-sided, right, it may sway the jury, and if they came back guilty, it would give the defendant a reason, right, to attack the verdict. Other reasons are that's just not what the law is. He's got to. He basically, I don't know that was incorrect. He basically just told them to go with what
their general understanding, but.
Yep.
Right, well, what I'd like you to do, I want to shut up in just a second, but what I would like you to do, Ross, from time to time when there's a discrepancy that sounds like, what is going on? Maybe you can give a clarification, no, that's cool, that's how it works. That there's nothing crooked about that, that's just the way it works. Or you can say, yeah, that was pretty screwed up, okay? Just so for people like me, the simple people out there can say, oh, I get it, okay? So
I mean, that's not abnormal. I was just trying to say that judges are careful about what they tell juries back there. They don't want to influence them, and they have those instructions, they've seen it, so commenting anymore, may sway it one way or the other.
Okay, go ahead.
But I think one thing we should do is let Mr. Grisham explain the factual underground, the foundation of how he got to this trial. I don't know that all these listeners know about, exactly how this happened. If we can.
Yeah, my son was working on his Eagle Scout, and there was one badge that he needed that was required, and he didn't have it, and that was either hiking, biking, or swimming. And he chose hiking. And we live out in the country in the middle of nowhere amongst farmland. My family's been farmers out here for centuries, or decades. Generations is the word I'm looking for. And so I told him, okay, well, we'll do a hike. And you have to do, in order to get your badge, you have to do 2 10-mile hikes and 5 5-mile hikes, something like that. So we had planned our first 10-mile hike, and I told Chris, my son, I said, plan something where we can start and end at the house, and we can just stay out here in the country. And so he planned a route, and I said I tweaked it a little bit, and it was out in West Temple. So literally at the halfway point of our hike, and since I live out in the country, I always carry a rifle on me. My whole family carries a rifle. We got them in our tractors, we got them in our trucks. I carry them when I'm on foot. And my rifle is an AR-15. That's just what I carry. I don't own anything but an AR-15 other than an AK, because being 20 years in the military, that's what I'm used to. That's what I'm comfortable with. I hunt with it. I train with it. I target shoot with it. So halfway through the hike, I got stopped. I heard something behind me, somebody calling at me. I turned around. There's a patrol car. There's no lights on. He just gets out normally. He yells something. I didn't quite understand what he said. The second time he said it, he said, don't be touching it. And I looked down. I just assumed he was talking about the gun, but I wasn't even touching it. My hands were down to my side. And so he walks up and he says, what are you doing? And the first thing I said to him was, how's it going? Fine, don't be touching it. That was how that worked. So I started out trying to be friendly. He asked what we were doing. I said, we were hiking. And then he grabbed my rifle and he said, what, is there some reason why you got this? And it was a bewildering question to me, honestly. I didn't expect that. So my answer was, because I can. And it was more of a question. I'm like, what are you looking for? Am I supposed to have a reason to be able to do this? And so at that point, when I said because I can, he got this, oh, okay, I'll show you. He's like, oh, okay, and he starts to disarm me. Well, I'm a soldier. In basic training, when that drill sergeant goes and he grabs your rifle while you're at port arms or inspection arms, you do not relinquish that gun. And if you do, you're dropping with it.
I watched that video, and you didn't do a darn thing. That's common sense. That's initial reaction. It's like, whoa, what are you doing, man? I saw it. That's my personal.
And it was all of a second, if that. I put my hands, I realized immediately, and I put my hands up.
Yep.
And then I ended up with a gun to my head and thrown onto the hood of a car. And that's when I got really irate, because I began to ask, what crime have I committed? Why am I being attacked? What crime have I committed? And not once did he say anything other than, well, I need to find out if you can legally have this gun. And I know that you can't do that. I know Terry v. Ohio, he's got to have some reasonable suspicion or probable cause to search me and detain me. And so that's the background for what happened leading up to the arrest. And of course, at that point, after the arrest, once he had thrown me against the car, that's when I realized, oh crap, I've got a camera on me, a video camera. And the reason I have that is part of the merit badge requirements is that you document your hike or your swim or whatever it is. And so we brought a camera in case we saw things that were cool along the route, because we sometimes see cougars out there. You might see some feral hogs. And so that's why I brought the camera. And at that point, that's when I realized, if I'm about to die, this is going to be on video, because I don't want something getting lost, the video or the dash cam footage or anything like that. So I got my own video. So I pulled my camera out and started recording at that point. And I know I've been accused of setting this up, but by golly, if I was setting it up, I would have had my camera on the moment I saw a police officer pull up. And I didn't think it was going to be anything other than just a few questions. So,
in my humble opinion, everybody knows it's screwed up, but everybody's covering their rear ends, and they're doing whatever they can. That's my personal opinion. Because when you see the video, ladies and gentlemen, you're just like, it's a no-brainer. It's a no freaking brainer. Okay, but go ahead, guys.
Well, and the only reason the video even got out was because shortly after the arrest, the police began lying to the media about what happened on the side of the road that day. And I'm like, that's not what happened. I have video to prove it. And so I had released 3 30-second clips from the full video to basically show that, no, they're lying about this. Look, here's what really happened. You can see for yourself. And then I found out, my attorney told me that they had filed to put an injunction or a gag order on the video. And he says, we got a hearing on this, on a gag order. And I said, oh, really? So I uploaded the entire video, because you can't put a gag order on something that's already out there in public. And so I uploaded the video. I put it into every gun group, and I said, download this, upload it to your profiles. I don't care. I don't need ownership of this. Put it out there. They're trying to hide it. And, of course, that didn't sit well with the judge when he found out that I had done that. But I didn't have a gag order on it. So, and that's the only reason.
You can't unring a bell.
You can't unring a bell. And that's really the only reason it went viral. I wasn't looking for fame. I wasn't looking for sympathy.
Okay. Now, because of the lack of time, you set this up. Ross, you've got some potential issues. Why don't we discuss that in the next 13 minutes here?
Okay. I'll say so. He essentially filed a motion to suppress as well, and tried to get. That's basically where your attorney is going to call the police in the state into a hearing and make them justify why they stopped you. Is the stop legal? Did the officer have authority under the law to stop you? And the problem with this case is what he's saying. Initially, there were some reports, and the probable cause affidavit is supposed to justify why they stopped, why they arrested you, when they arrest you without a warrant. Because unless they have that, that's supposed to be a sworn statement by the police officer about why he was justified in doing what he did. And then their report, they're supposed to be as thorough as possible. They go to school on this, and they train, and they're supposed to put down everything that they see and everything that they observe, and their justifications and articulation. Right? How it got upheld on appeal is the appellate court saw what was said at the suppression hearing. The appellate court meaning the third court in Austin. And there they said that this was walking on the wrong side of a road. Okay, and so that was what the officer said at the suppression hearing. But in his report, he talks about Mr. Grisham being threatening, flailing his arms around, using his firearm inappropriately, and in fact, he never touched the firearm until he started to unstrap it from his body. Okay, and so there's problems here because he never says anything about walking on the wrong side of the road until we get to the suppression hearing, which is that they went back and watched the video, or somebody told him, or they make it up later, or it wasn't the reason that he stopped him. In fact, even in the debriefs to the court, they cite some of the hearings that he was going to go see if Mr. because there was a call as well. There was a non-emergency line number call from a person who was actually, I found out today, a social worker for the state. She called and said, well, I see this guy walking down the road, and he's got this firearm, and I think it's kind of odd. It's kind of odd. And she said he's not waving it around, he's not doing anything threatening. I just thought it was odd, and so that's why the police shows up, right? And this is legal; it's completely legal. Walking down the road.
I understand.
There was nothing wrong. I want the listeners. There's nothing wrong with walking down the road. So there was no reasonable suspicion, right?
Wait. There's no problem with the officer getting the call saying, "Hey, something's going on." Yeah, they got to respond. totally dig it, man.
So do I.
It's the reaction of what happened. Go ahead.
But even then, like, still, that call didn't give rise, in my opinion, to reasonable suspicion just based on that call alone. I think that, you know, there wasn't a good reason. Now, I know that courts are going to disagree with me, and that's what I was really wanting to talk about. That's why I get so passionate about these issues, because that's how our society has grown. But anyway, just to be clear, so the reasonable suspicion, the justification for the stop in this case by the Court of Appeals was said to be walking on the wrong side of the road.
That was after the fact.
So he mentions Terry versus Ohio. I want to just start out by saying, and I'm going to hurry. I know we're kind of behind on time, but at the very beginning of the founding of this country, we had a probable cause requirement, and that basically required direct vision of somebody committing a breach of the peace. The police officer sees somebody committing a breach of the peace, a theft, right, or has a sworn affidavit on a piece of paper by somebody that's a credible person, right, and giving that officer an objective justification to go and get probable cause to arrest somebody for committing a crime, actually. Right? As time goes on, we develop all these exceptions. We have good faith exception. We let police officers basically say whatever they want to, right, to justify an arrest or a stop, right, under certain circumstances. And we've even gotten to the point now where they don't even need probable cause. They need reasonable suspicion. And for the listeners, this is very important, because it will shock you to learn that you don't even have to be doing anything criminal, right, to be stopped. Okay, it can be completely innocent activity. I've actually taken a case to the Court of Appeals because the kid got stopped when he drove around a parking lot 3 times, not in any kind of manner. He was circling the parking lot looking for the friend he was picking up, and he got stopped and there was marijuana. But anyway, right, I think that was a bad case too, but that's neither here nor there. It can be consistent with innocent activity, and they can stop you. Terry starts off, right, he's walking the beat and he sees people casing the joint, which is almost criminal attempt. They're almost attempting to burglarize a place, right? And reasonable suspicion says that our justification at the beginning of the stop, an officer has to articulate, right? Articulate what his justification is, and it has to be justified at its inception. It means at the initiation of the stop, at the beginning of the stop, that stop has to be justified, and it has to be based on the officer's experience and facts and his personal knowledge of observation of those facts. Now it can be based on callers, okay? Based on those things and his experience putting them together, right? Does he think that there is a crime that's about to be committed or has been committed, or that crime is basically afoot? There's something criminal here.
I want to say something that's going to like freak people out. In a manly way, that's so freaking attractive what you're saying, because you are so passionate. Ladies and gentlemen, this guy, he's not an attorney. He is an attorney who loves what he does and looks at it and says, he's a common man just like you and I. And he's like, that ain't right. And he applies the law in its proper form and fashion. That's what's so exciting about you, Ross. I love it. Go ahead.
This thing is problematic because this is a retroactive justification, okay? And yeah, I know that the courts are going to disagree, and I know that there's prosecutors who are going to say I'm wrong, and they're going to say I don't know what I'm talking about. And to some degree, they're not completely unfounded. Yeah, the facts, he was walking on the wrong side of the road. We watched the tape, that's true. Okay, but that had nothing to do with the situation. And now I'm not the only one who has this idea, because there are split decisions across Texas. There's actually about 5 or 6 cases that I know of that I've used, right, where, for instance, one was a case, and when I say retroactive, meaning the police officer went there to stop him to check for weapons and crimes and using the gun. Right? It had nothing to do with walking on the wrong side of the road. That was not a legal stop. And this would have been illegal, right, if the officer didn't have some legal basis to stop him. So they came back and said, oh, well, I could have arrested him for walking on the wrong side of the road, so now walking on the wrong side of the road was my justification.
What about all the other people who walk on the wrong side of the road, but they never stop in the first place? Let me make a comment about that. Like when I was in real estate, if I have a contract that says you need to pay on the 3rd by the 3rd of the month, but I let it go to the 15th, I just set a precedent that says, until I write another notification saying, hey, look, I know I've been letting you go to the 15th, but we're going to readjust it back to make sure we're both in the same sheet of music. How could an officer say, I see 100 people walking on the wrong side of the street, but I don't stop them?
Right, and what I'll tell you is I filed a request, an open records request after this suppression hearing, because that's the first time any of us, my attorney, me, anybody, heard walking down the wrong side of the road.
Because nobody gets stopped by that.
No, and not only that, the entire court burst into laughter when the officer said it, and the judge had to pretty much shut everybody up. But
that tells you everything right there.
In the previous 10 years, the city has not cited nor charged anyone with walking down the wrong side of the road ever.
That's your evidence right there, man.
Look, and tell the listeners, what kind of road was this? Was it like a highway where there was tons of cars going down? At that time. Now it's built up, but what was it?
Now it's built up. It's a completely rural road. I was literally surrounded by pastures, one of which on one corner was our family pasture. Literally surrounded by pastures. I'd only passed 3 homes the entire 5 miles that we'd gone into, and those were all my family homes, my aunts, uncles, grandparents. And not only that, but if he would have said, I stopped you for walking down the wrong side of the road, yes, I would have been like, what the hell are you talking about? But I wouldn't have been as belligerent, because now I know, okay, he's investigating a crime. But it was never brought to my attention that I was walking down the wrong side of the road.
And I'm telling you, he didn't know. He did not know. He did not know this. I can't prove that, and he may come and say that he did not know. No. And under the court system, he didn't have to. They're saying now, well, because this was factual. I want to get to what I was really saying in that email, and this is dangerous.
Everybody knows.
Look, I want the people to understand, like, the government is growing, and it's growing more powerful every single day, and I'm not a conspiracy theorist. I don't think that all the government is conspiring to get us. I think it is a systemic bias. I think it is a culture within the court system, within the legislature. I think these things happen just as a natural course as we get those slippery slope type arguments. I don't think everybody's out to get everybody, but right, it's a good old boy system in many cases as well, and that's what leads to these opinions that are bad for society. Okay, there are 500,000, probably 450 to 500,000 federal laws and regulations on the books that carry criminal penalties. Okay, and that's only on the federal level. When we look at the state level, we have at least half that many. There may be more. There may be, nobody's ever counted for sure. We know there's at least 450,000 criminal regs on federal level. There's at least 5,000 laws on the criminal code books. That means, and Robert Jackson said this, we don't need to, if a prosecutor can pick his cases, then surely he can pick his people. And he can go back and search the code books for any reason to get the person, to pin the charge on the person. And that's exactly what this situation is akin to. He's walking down there minding his own business, not doing anything wrong, and they come back, they search the code books for a way to justify an otherwise illegal stop and to say that it was justified even though he was doing something that the law gives him a right to do. And I didn't mean to interrupt you.
Yeah, well, I was just going to add, too, that this judge wasn't even a local judge. None of the judges in Bell County would take my case. And instead of just they never said it, and they weren't required to give a reason. They just recused themselves. And so what the prosecutor, or whoever does it, I don't know.
Are there backdoor channels that says you better not do this because, I know you're a Texan, I know you understand it?
Probably. And so they go down to Harris County and find a retired judge out of Harris County that when he retired had a 20% approval rating among judges, which is probably why he was forced to retire. They bring this anti-gun judge up here, and he's the one that hears my case.
Ladies and gentlemen, do you hear that? Do you hear your legal system? If you don't hire this guy, Attorney Benton Ross Watson, you're nuts.
This is not unusual situation. They're starting to go back and try to justify situations, and basically a court is going to uphold whatever an officer thought it was reasonable. There was another situation I do want to get to. I do want the listeners to know too. What's so messed up? Nobody knows, and this is why there's so many laws out there. This is why the law is vague. The law can be vague in its language, and we've talked about that. We've had debates even at on radio, like what does this mean? Even today with the device situation, right? But their laws, in my opinion, can be vague by the sheer vast number of these laws.
That's right.
And so, like he was saying, this thing has never been charged or prosecuted, and hardly anybody even knows about this, and they sure wouldn't expect that to happen on a backcountry road at the time like it was when he was walking. And so, I'm going to get there. So the Supreme Court said in North Carolina versus High End that an officer, ignorance of the law is no excuse.
That's right.
We don't get saved by ignorance of the law. An officer in that case did not know what the law was. He arrested somebody, he stopped somebody and arrested them, right? Because he thought that it was illegal. What they were doing was absolutely legal.
Well, that's good.
The Supreme Court said it was good faith. In some situations, an officer's ignorance of the law will excuse it, and it will justify his stop. How?
So much for equal protection.
Now look, let me make something perfectly clear. I love law enforcement. I back law enforcement. I think they put their lives on the line every day. But sometimes mistakes happen. You need to fess up to it and let the citizen go because you made a mistake, man. That's the deal. Now look,
I think this whole case has an ego.
I got 2.5 minutes left. Let me wrap this up.
Okay,
guys.
There was also an issue with the jury charge. He asked for a self-defense claim, and the thing is he wanted to say that it was self-defense and what happened. Okay, you said it was a natural reaction. The third court, you got to let me say this because I've been trying to go after the third court on this deal. They said he wasn't defending his person, he was defending his weapon.
Right? They said I was defending my right to carry a weapon.
Well, they said, I just read the opinion. They said he was defending his weapon, right, not his person. They said that too, okay? But I want to read the Texas the Texas Supreme Court's decision in Fisher versus Carousel. It's a 1960s case, and it's a famous case, and it says, unpermitted and intentional contacts with anything so connected with the body as to be customarily regarded as part of the other person's body and therefore as partaking its inviolability in actual as offensive contact with the person. There are some things such as clothing or a cane or indeed anything directly being held by the hand which are so intimately connected with one's body as to be universally regarded as the person. So to say that he was only defending his weapon, right, something that was secured. When he goes, and also when you make an arrest, you have to manifest your purpose and reason for doing so, and he didn't. And we've said there was never been anybody arrested, or hardly anybody arrested for this offense. And I guarantee you, if you ask reasonable citizens, they're going to say that they've never been arrested when they've been stopped for a traffic situation. Okay. You don't expect to be arrested, and so when he grabs this strap on his shoulder, right, I believe that there was nothing unreasonable about that. It should have been submitted to the jury.
CJ, 15 seconds. How can people get in touch with you?
Again, go to opencarrytexas.org. I do have a crappy website, cjgrisham.com. It was just something I did for a school project, but opencarrytexas.org is the easiest way to get a hold of me. CJ at opencarrytexas.org, and I'm on Twitter, Facebook, all that kind of stuff.
Ross, tell us how you get a hold of you.
Again, 105 East Main in Cameron, big milk cow on the side of the building. 254-455-0569, 254-455-0569, Benton at Watson.legal, Benton at Watson.legal. Thank you.
Ladies and gentlemen, if you like this show and you want to support it, do it, because otherwise it goes off the air. Thank you for listening, and until next week, keep your powder dry, and God bless.
I cut your mics. Mics are off. Mics are off.
God, kill this. Is that dead?
Nope.
Awesome. That was awesome.
It was good. Yeah, I learned a lot. I didn't know what that case was. Because I could use that. Although now that I've decided we're not going to appeal it any higher, because